Hi, everybody. My name is Tammy Berman, and I'm happy to introduce Evan Barron. We're here today to talk to you about some unique aspects of family law, specifically paternity, in light of dealing with quarantine and coronavirus, and also just to give you some education around what is paternity and what are the benefits, why do people need paternity, as well as how the collaborative process can serve you in paternity. So I'd like to just say that my background is a mental health professional. I'm a licensed mental health counselor. I work in Plantation, Florida, which is Broward County, South Florida. And my training is also as a collaborative facilitator in collaborative divorce and family law. And I'm a certified family mediator and a parenting coordinator. And my specialty is really helping people through the divorce process, as well as other things. But this is why I'm here talking today with Evan. Evan, why don't you tell us a little bit about your background?
Sure. Good afternoon, everyone. My name is Evan Barron. I'm an attorney. My office is in Weston, Florida, which is also in the Fort Lauderdale area. I've been practicing now for about 40 years, and I focus on family law. I've been doing years and years and years of litigation. But in the last several years, I've kind of became familiar with the collaborative process, and I realized that that was really something that I was interested in. And I felt that it was best for me, but more importantly, it was best for my clients. And I think today we'll explain a little bit about the collaborative process. But as you see, we're now talking to you virtually because most of the courthouses are closed. They are closed down here in Broward and Dade County. So everything is being done virtually. And the benefits of collaborative is that it can be easily done virtually. Just like we're doing it here today, we can have a collaborative meeting without being in person, without in any way worrying about the effects of COVID virus, keeping safe, and we can still get everything resolved. And so this is a perfect type of resolution to a family law case.
Right, and especially in light of the challenge of getting access to the courthouse when maybe you need to see a judge. So this option is really amazing to have Zoom and for us to be able to meet virtually, and that's typical of what the collaborative meetings are. So I want to facilitate a conversation so people can really understand about paternity. You know, I just learned about paternity honestly in the last few years working in the specialty that I have. So I'd like you to help us, me included, because I'm sure I'm going to learn stuff from you, Evan, to explain what is paternity.
Well, it's when a child is born out of wedlock, when parents are not married, there's still an issue of establishing who the father is. We obviously know who the mother is, so we have to determine who the father is. And just by putting someone's name on a birth certificate is not going to be sufficient. So oftentimes what happens, and when paternity actions usually come about, is when we either get contacted by the mother or the father in regards to establishing who the father is. Now, why do we care about who the father is, or why do they care? Well, for two reasons. One is obviously there's issues of financial support, and there's also issues of responsibilities in regards to time sharing and things of that nature. So if a dad wants to be considered to be the father of a child and have all the rights and responsibilities that he would have if he was married to the mother, then we need to go through a paternity suit. And then we get a court order which establishes that dad is dad, and then he has all the rights, responsibilities that any father would have in these types of circumstances as if they were married. But it's just something that needs to be done because under Florida law, until it's established that he's the father, then he doesn't really have any rights, and that becomes a problem.
Got it. Just curious, how does the court establish if dad is dad?
Well, 99% of the time, most of the time, the parties agree. I mean, I've had very few cases where mom has denied that this is the father. I've had some cases when the father denied he was the father, and then DNA testing is required. I remember I had one case where my client absolutely denied he was the father, and we went down to court. It was in Miami, and there was mom with the child that he had never seen before. And because it wasn't a long-term relationship, and they had been apart for quite some time, but she had filed a paternity suit to establish some type of child support. We went down to court, and there was mom with the child, and I looked at the child, and he looked at the child, and it was literally looking at a mirror, just seeing this child look exactly like him. And he looked at me and said, okay, I'm not going to contest this anymore. So sometimes it could be that simple, that they just recognize the fact that this is definitely his child, and they don't have to go through a DNA test. But if they don't, then the courts can order a DNA test. And obviously that's going to come out with whatever the results are.
Got it. So far what I'm understanding from paternity is what's typical is a financial aspect, needing support to help with the child, as well as access, because they want to have a role in the child's life. And so in that case, when they're not married, that's where paternity covers those issues. And
Right.
the way that the court establishes that, you're saying in most cases, is that the parents agree. They just need to let the judge know, yes, he is the father.
Right.
And if there's an issue of a question of whether or not that's the case, then they would possibly do a DNA test.
Yeah, I mean, I've had cases where the parties have been basically acknowledging that that's the father, but not on paper, not through a court order.
Mm-hmm.
And then something happens. There's an issue, there's an argument, there's a third party comes into play. Dad gets a girlfriend, mom gets a boyfriend, whatever it may be.
Right.
And suddenly this very cordial relationship breaks down, and now dad doesn't have the power to be able to see his child or children. So then they have to go forward and go to court to be able to establish those rights.
Got it.
It's unfortunate that sometimes it gets to that point, but it does, because as we know, any relationship is full of emotion, and it can go back and forth.
So with regards to collaborative, which is something I'm really passionate about, and I'm happy to be here talking about collaborative with you, but as you've done litigation for a long, long time now, you're entering into collaborative. I know you believe in it. How do you see collaborative helping resolve the issues? What are the benefits of collaborative?
Well, I think if there's any type of case that cries out for collaborative, it's a paternity case, because we don't have all the issues we have in a dissolution of marriage. There's no equitable distribution. They're not separating property rights or liabilities. It's simply really focused on the children. And to go into court and fight over things that are so basic. I mean, child support is very easy to determine in Florida. We look at the income of the parties, we go through the child support guidelines, we calculate what it is.
Mm-hmm.
And then a parenting plan, basically we have a form that spells out exactly what we need to cover.
Yeah.
So, if we go to court, a judge isn't going to want to get involved in these issues. Judge is going to send the parties to mediation anyway to try and work it out, so if there's an opportunity to kind of sit down and resolve this without the emotional aspect of court, without the cost of court, with all the necessary documents going back and forth and hearings and possibly getting other experts involved and things of that nature,
Mm-hmm.
this is the best way, because the parties will hopefully end as loving co-parents, and that's the benefit to children. And
Yes.
it's such a simpler, more basic, easier, peaceful prospect or project to go through.
Yes. I would say the other pieces that I would add to it, it's a transparent process. So if there were attorneys involved on both sides, the idea is not to withhold secrets or information, but to share information for the sake of helping the clients come to agreements together. And the other thing about collaborative that I love, which is it's not a requirement, it's not in the statute, but it is a very common thought process, and a part of the process that's available to clients, which is having a neutral facilitator, which has to have a mental health background, because we have to have a specific set of skills in terms of conflict resolution, emotional sensitivity, being highly specialized in communication. that part is often chosen, especially with paternity, because you're dealing, oh, and also in human development as well, you know? So, and when we're talking about kids, this part I really believe is so beneficial in a collaborative process, because it's typically set up to support having a person to help these clients address all these different emotional issues, as well as sensitivity to the needs of a child in the process. So that part is really good and beneficial, as I see it, where it's not typically set up that way. It's not always a thought process in litigation or mediation. So, and often in collaborative, when there is a mental health facilitator, a neutral facilitator involved, they usually, we are the ones that do help facilitate discussion around the parenting plan, and helping those clients identify the needs that are important to them, the needs that they know are important to their child from their perspective, having sensitivity and understanding, an appreciation of the perspective of their co-parent and how they might see it differently, so that, you know, we do a lot of that in our intake, so that we can help improve the potential of them having conversations that might be challenging, but that are in the best interest of getting to like a mutual resolution, mutual understanding. So that part I really love. Yeah.
And unlike a dissolution, when the parties have been married and they have a relationship where, you know, until the dissolution takes place, they're basically living together and they have a life together. In a paternity case, you may have two parties that have had very little contact over the course of many years. They've had a child together, but they really haven't sat down and communicated. And the collaborative process, it gives them an opportunity to talk, and not in court, but to talk to each other through you.
Right.
And like you said, to learn about each other and learn about what's important to them. And maybe they may have the same interests and the same motivations, but they haven't discussed with one another. So it gives parties a chance to sit down and talk to one another, which to me is very important. And the other aspect of collaborative is they don't have to worry about what a judge may or may not do. They have the right to be able to work out anything they want to work out. The only thing that has to be established generally is the child support, which is statutory.
Mm-hmm.
But other than that, it gives them a lot of freedom, and they don't have the court breathing down their neck.
Right. So some unique issues that collaborative can deal with well, that I would say there's not a lot of room in litigation or mediation to deal with, is unique issues like special needs, needs of an adult child, you know, the consideration and concern that maybe both parents or one parent has for their adult child, that maybe they're both still involved in caretaking and they want some kind of agreement in place. So collaborative can really support that opportunity. So, and also the timeline part, you know, it's a client directed process. So it's really up to the clients to determine how quickly or how much time we need, how quickly we could get this done, and or how much time we need and to provide to get this done. We're not at the mercy of a judge's docket and a certain protocol of like, you have to file this motion to address this thing and uncover this information. And that part is also really great about collaborative. It's more cooperative and collaborative.
Right.
Yeah.
And I think at the end, the parties will be more likely to co-parent the children and not be fighting. And I think how a case ends will definitely affect how it is going forward. I truly believe that.
Yeah. I feel that you would have seen that so much more than I, in terms of going through so many divorce cases and paternity cases. I see clients for so many different reasons, but I certainly, the ones that I have seen from an emotional standpoint, where it's therapeutically or as a facilitator, you know, the impression is more positive. As we end together in a collaborative, the communication and the relationship appears to be more positive.
Right.
So another question regarding paternity. a big piece, it seems like the main piece is the parenting plan. I understand financial issues are as well a part, but let's just talk about the main components of what does a parenting plan address for clients?
Well, parenting plan addresses pretty much every aspect of co-parenting. It deals with most importantly time sharing, whether it be the weekly time sharing or holiday time sharing. It deals with parental responsibility. It deals with each party's responsibility, both financially and otherwise, for extracurricular activities for the children. It deals with school boundaries, whose address is going to be used for purposes of school boundaries. It addresses communication between the parents and the children. It deals with vacation time, whether or not the parent can take the children out of the county, out of the state, out of the country, whether there's certain permission is necessary from the other parent or court permission, whether in fact they need to give advance notice, how much advance notice, things of that nature. It also deals with relocation, which is when a parent who they've already most times established the time sharing, oftentimes though it can be before that, where one parent wants to move more than 50 miles away from the other parent where they're living now, and there's a statute in place which says that no parent can take the children more than 50 miles away without either consent of the other parent or court order. And I will tell you that collaborative would definitely be something that would benefit a relocation case. And I'll tell you why. One is because if you ask any judge in family law, they will tell you that the absolute most difficult types of cases that they have to deal with are relocation cases. Because number one, it's pretty much never going to be a compromise. You know, when you're dealing with nickels and dimes, you can, always find a middle ground. But when someone wants to move to New Hampshire and they're living in Florida, what are you going to do? Okay, I'll meet you halfway. We'll meet in Maryland or something like that. You can't do that. So judges don't really want to get involved with the relocation aspect. And I do believe that if parents sit down and try to make the other parent understand why they want to relocate, or why the other parent says, no, it's not in the best interest of the children, there's much greater chance that they can figure something out. You don't want a judge making that decision if you can help it, because it's going to be what the judge says, you're done. And neither parent may feel very, very good about it. So
Well, that's interesting. I've been a part of quite a number of collaborative cases. 2 of them were relocation. So I did not know that it was that was the case in the legal system, that relocation is so difficult. But we were able to draft agreements that were pretty comprehensive around major moves out of the state. So that's good to know that if that's a part of your process, then collaborative certainly will serve you better too. What would you say are the situations where you might bring in a financial neutral, which is an option, and typical in divorce cases? I don't know how typical in paternity cases, but what kind of circumstances would you say that we would bring in a financial neutral into collaborative for paternity?
When there's a question about the actual income of one of the parties. So, I mean, if somebody's a W-2 employee, it's pretty easy to figure out what they earn, and we can usually calculate child support pretty easily. But if someone has their own business, or they're not salaried, then there might be a question about what the actual income is, whether they're using paying off private expenses or private bills with their business income, and so we have to add that back in. Where there's other sources of income that maybe are not being divulged, and there's a question about whether or not we're getting the actual figures. So at some point we may need someone to step in and do some investigation to determine, for purposes of child support, exactly what it is that they earn and how much child support is due the other party. But again, if we know what the income is, it's not that difficult, but that's not always the case.
What would you say are the circumstances that would necessitate bringing in a child specialist? So this is another option to the collaborative that, I mean, really in collaborative, probably in litigation mediation too, you can bring in other specialists, but what would be the circumstances in a collaborative paternity case that you might bring in a child specialist, do you think?
Well, when you're dealing either with, let's say, time sharing, or we're dealing with maybe relocation, the issue is what's best in it, what is the best interest for the children. And, mom's going to say, well, the best interest of the children is what I want. And dad's going to say, well, the best interest of the children is what he wants.
Mm-hmm.
But it may be somewhere in between, or maybe one of them is right and the other is wrong. So how do we determine that? Well, we need somebody really to be able to talk with the children, or do some type of therapy with the children, and find out exactly what is in their best interest. Maybe there's a reason that they shouldn't be with dad 50% of the time, or mom with 50% of the time, or they shouldn't move out of state. There's a lot of issues. How is it going to affect them?
Mm-hmm.
And the only way we're going to know that is if somebody really does an investigation and delves into what is best for the kids.
Right.
Because,
and then they become a voice for the children in the process, which is great, because as a facilitator, we have kind of a strict guardrail upon which we can maneuver and help a family through the process. But reaching out and speaking to children is not customary as the role of the facilitator. So if we feel we need that input, we're going to call on another professional to be that person. Yeah.
Right.
So there's some questions that are commonly asked, as I've learned, and I want to ask some of them to you because I believe that these are not commonly known or by the public. So here's some questions. What if I'm on the birth certificate and the child has my last name? Does that mean my paternity is established?
No, it doesn't mean it until you get a court order to determine the paternity. Now, I'm not saying that can't be used as evidence to establish that in fact you are the father of the child, but you still need something in writing from the court order which establishes paternity, so that you can have all the rights and obligations that any father would have.
So now, if that happens, does then the father go on the birth certificate? And if not, how does a father go about getting their name added to a birth certificate?
Oh yeah, if there's an order issued that declares him to be a father, yes, they will amend the birth certificate to establish him as the father of the child.
Got it. Another question, if I'm not the legal father, but I have a DNA test proving I'm the biological father, do I have any rights at all?
Well, if there's already been established a legal father, in the sense that maybe the child was born during a marriage and there was someone else involved, that may be a difficult thing to be able to establish paternity with another father. Because under Florida law, if the child is born in a marriage, then those are presumed to be the parents.
Wow.
So that could be a difficult process to be able to establish that.
Got it.
And
they would have to go through a paternity action. There would have to be.
Right. And it would be much more difficult as a child gets older, because the courts aren't necessarily going to declare someone else to be the dad when what you call the legal father has basically raised the child. Because again, you got to look in what's the best interest of the child, and how is that going to affect the child emotionally.
Wow. Got it.
It's not always that cut and dry.
So another question, is it always necessary to have DNA proof?
Not if the parties agree. Again, if the parties consent that these are the parents, then there will be no necessity for any DNA testing.
Okay. And what documents do I need to establish paternity?
Before the paternity suit is filed, you just need the agreement of the parties, basically, in a birth certificate. I mean, a lot of times the father's on the birth certificate already, and we just file that. If they don't agree right off the bat, then it's going to be a matter, again, of the DNA testing and subsequently a court order. Got
it. Based on what you're saying, it sounds like most of the time they both agree. This next question is saying, what's the likelihood I'll gain rights over my child if I file a petition to establish paternity? So how would you answer that? In most cases, they're agreeing. So,
I mean, if it's established that the dad is the dad, then he's going to have the same rights as any other dad would have under any circumstance. I mean, I don't know what those rights are going to be because every case is individual. So it's not a blanket rule and say, okay, you're the dad, you automatically get A, B, and C. You establish that you're the dad, and then the case is handled like any case would be in regards to time sharing and things of that nature.
Got it. If I'm not the legal father, but I am the biological father, do I have to pay child support?
Well, the only time you have to pay child support is when there's a court order establishing your responsibility for child support. And again, unless you are found to be the father, then there's not going to be any responsibility for child support. Where that person wants to pay anyway, that's up to the individual. But again, once paternity is established and it's established that you are the dad, then child support is going to be established. And by the way, it's not always dad paying child support. Mom pays child support too. So
yeah, that was one of our cases, wasn't it? Oh no, how did we work it in the end in our case? I can't remember. But I know that the income was far greater on the mother's side.
Right. And again, that was an example of two parties who, if they went to court, would have gotten totally different results, I believe. But the fact that they sat down together over a course of several meetings and were able to establish it, and look, neither you or I, we talked about this yesterday, we haven't heard anything from either one of them in months, which tells me that everything's going smoothly.
Yes, and you also got feedback that they made certain agreements they wanted to just change quickly before the final parenting plan was drafted, all on their own, which is wonderful.
Right. So they're working together.
Mm-hmm.
And they're taking care of their kids, and they're being, from what I know, they're being very flexible with one another and helping each other out. And that's the best thing you can hope for in going forward.
Yeah, for sure. That was a great case to see how adversarial they were. I think a big piece for them was finally having a map, a plan that was agreed upon. So that there was no discrepancy. Like, I know what I'm doing, you know what you're doing. That was a big part of their dynamics that was problematic, is just not having a roadmap together. Right. That was definitive, communication, right?
Right. They couldn't communicate. And we sat there and they did, and they both realized they basically wanted the same thing for their kids. They just were both going about it different routes until they finally figured it out together.
Yes. So just a few more questions and then we'll wrap it up. This question is it true that courts favor the mother?
No.
I feel like that's an obvious answer, but maybe that's a common question that comes up.
It is a common question, and mostly it's dads that ask that. Oh, doesn't the courts favor mom? Mm-hmm. And the answer is no. The courts favor the children, and that's what it really comes down to. There are many cases where dad gets more time than mom does. That's because the circumstances suggest that it's in the best interest of the children that they spend more time with dad. When I first started about 100 years ago, I probably would give you a different answer because it was generally mom had the kids most of the time and dad had every other weekend. And that was kind of established as the general rule. Mm-hmm. That has changed. And in most cases now, if not all, you're seeing 50-50 or very close to it.
Right.
Unless there's a reason not to. So the answer to that is no. Again, courts favor the children and whatever's best for them.
Yeah, that's good. Once I am determined the legal father, what rights do I have? So that's time sharing, that kind of stuff pertaining to the parenting plan, or no?
Yeah, you're daddy. You have the same rights as anyone else does. And it's no different than if the parties had been married and they were going through a dissolution and determining what's best for the children. You know, one thing that every judge will tell you is their focus is always on making sure that children are protected and it's in their best interest. You know, the parties are adults. The children need to make sure that the court's there for them.
Yeah. Yeah, which I've learned a lot about that being the definitive, the focus is the best interest of the children. And so the case and the arguments are all around proving that for mom's case to fight versus dad's case. That's the thought process. That's the orientation and focal point of a judge, is what they're looking for, which is great if you have to do litigation. It's just that there's less opportunity to really have conversation and problem solving and work things out together, as much as it is a lack of communication and adversarial process. Positions are taken, very different than collaborative, where we're trying to support mutual interest building options.
Yeah, it's amazes me sometimes how two parents, whether they were going through dissolution or paternity, that have spent many years together, just never communicated. And when they sit down in the collaborative process, they finally get to communicate and learn a lot about each other.
Yeah.
Which probably, if they knew that before, they wouldn't be sitting in the room with us, either for dissolution or paternity case. They've been able to work things out on their own.
Yes. Okay, last questions. If I'm the biological father, but not yet the legal father, does the mother have the right to leave the country, state, county without my permission?
Until it's established that they are the father through a paternity action and a court order, that father does not have the power to stop them from leaving until it's established that they are the father, and then they will be able to file whatever necessary documentation to try and stop it. And I had a case just like that where mom took off with the kids and he was never declared to be the dad. We went into court and he wanted to try and bring them back, and the judge says, well, you haven't established your paternity, so until you establish your paternity, I don't have any power to do anything, which was correct. So we had to go in and establish paternity. And by then, if you wait too long and they establish a life somewhere else, it's going to be that much more difficult.
Got it. So if in your case, and that was going to be my next question, if he successfully establishes paternity, then can he make her come back, or it depends on where they're at in terms of the life they've established out of the county, country?
Yeah, I mean, unfortunately, he can't make them do anything. It'd be up to the court to determine whether or not it's in the best interest that they stay up there or come back, whatever it may be. So, but it's always harder to bring somebody back as long as they haven't done it against Florida statutes and done it properly. Mm-hmm. So if there was already an established parenting plan and they're trying to relocate and they don't do it properly, file their relocation petition and try to get permission and just take off, well, that's easy to bring somebody back because they violated the law. But if they do it and there's no paternity established and there's nobody really that says that they can't, then it's much harder to bring somebody back because they haven't done anything wrong.
Got it. Is there not, if there's a parenting plan in place, this is my own question. This happened with a client I was doing therapy with, that his family relocated. He was really on the fence. It was not agreed to in the parenting plan. She didn't go through the court. She just up and moved, and he felt kind of strong-armed in terms of dealing with that and was contemplating trying to fight for his kids to come back because they moved out of state. And what he was told was that there was a 6-month time of, once they're gone for 6 months, they've kind of established a new life and you're no longer in jurisdiction. Is that correct?
Yeah, it's the Uniform Child Custody Jurisdiction Act, which establishes that once you're in a jurisdiction for 6 months, that becomes the home state of that particular child. But the question is, if they did it contrary to the law, then is there an argument that you could say, well, they established it, but they established it contrary? The reality is, if you wait 6 months, I think you are going to have a difficult,
harder time.
It may be an impossible time at that point.
Got it.
Because they can then file something in that jurisdiction to establish if nothing's been filed down here. So.
Right. Well, thank you so much for answering all these questions, and it was great having this conversation. I mean, me personally, I love talking about just sharing information about collaborative and about family law to help people better arm themselves with information and prepare for whatever their situation is, the more information that you have, the better. So I'm thankful for you including me in this.
Absolutely. Thank you. And I just think there's so many people out there that don't really understand what collaborative is. And I think the more we can educate them, the more the light bulbs are going to go off and say, wow, that sounds like something that would benefit us, what we're going through. Or some people may say, wow, I wish I would have known about that when we went through our dissolution. We could have saved a lot of money, a lot of time, and a lot of aggravation.
Right. And then they'll be the advocates for their friends that like, you should look into collaborative because I've heard this and it sounds really great. Try that before you go down the road of litigation.
Absolutely.
Yeah. So that
Okay.
part's good too.
Well, everybody stay safe.
Yes.
And hopefully we'll hear from you in the future.
Yep.
Evan Barron, my law office is in Weston. And if you have any questions about collaborative, paternity, or anything else, feel free to give us a call.
Yep. And this is Tammy Berman signing off. And if you ever have any questions from an emotional, family logistical standpoint and navigating divorce or paternity, you just want to hear an emotional perspective on the process, I'm happy to answer any questions for you as well.
Okay. Well,
goodbye.